The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Two cases will be submitted this morning. Those cases are Sherry Kinseth and Ricky Kinseth, executors of the estate of Larry Kinseth and Sherry Kinseth individually, versus Weil-McLain and the state of Iowa. And the second case is in the interests of A.S. We'll now hear the arguments in Kinseth. Ms. Farris, you may proceed.
May it please the court. I'm Misty Farris, here on behalf of the Kinseth family. The plaintiffs in this case applied for further review before this court because the Court of Appeals decision reversing the judgment failed to follow some of this court's precedents and to give appropriate deference to the trial court's rulings. Most notably, Weil-McLain, the only trial defendant in this case, argued to the trial court and to the Court of Appeals that misconduct by plaintiff's counsel during closing argument caused such prejudice that a mistrial or reversal was required. The trial court that oversaw the trial, witnessed the argument, was with the jury during the trial, did not see prejudice that required mistrial.
Okay, but did the trial court apply the right standard? I mean, do we refer to the trial court if the trial court applied the wrong standard? And what I'm referring to is it seemed that Judge Carroll indicated in his rulings that he was not going to consider statements in the closing argument that were not objected to at the time. That were, in other words, that you had to object to every single statement during the closing argument in order for that to be considered in his ruling. And that doesn't seem to be our law, does it?
Well, when he ruled on the mistrial, he found that he was not going to rule at that time on things that had not been objected to. But when he ruled on the post-trial briefs, in his post-trial ruling, he considered all of the closing argument, including things that had not been raised in objection before, and considered what the plaintiff's counsel had said and also how Weil-McLain had argued in response to that. So there were two times that the closing arguments were reviewed. Once after the argument, before the case went to the jury, and then again it was raised and ruled upon during the post-trial hearing, or after the post-trial hearing.
Well, it seems to me some of the statements at least were across the line. Particularly, there's a statement, an oral argument about costing between $4 and $20 million. And that's not an attack on the experts. That strikes me as a comparative statement. Mm-hmm. You don't find out until you're sick. That was part of the statement made that suggested that, kind of challenged the law with respect to the difference between installation and the statute of limitations on installation versus ongoing. And then there's the send a message argumentation. Now it strikes me, and I invite you to push back, but it strikes me that these are over the line. And do you agree with that?
I would say that I do not believe that everything that the Court of Appeals pointed to, or that everything
I agree with you on that.
said,
I agree
but
with you on everything, but I want to
things,
focus on the 3 points that I had.
I do believe that there are things that were said in closing argument that it would have been a better decision not to say. Counsel agreed that she would not send a message, and she did. She also said things that that made it clear that the compensatory were to make the family whole. So even with what she said, there are some mixed statements there. But I would agree. I would agree that it would not have been unreasonable for the trial court to have ruled the other way, given the argument. But I also don't believe that the Court of Appeals deferred to the analysis of prejudice that the trial court made. And the court did look at that.
If we could, I'd like to shift gears, because one of the issues that concerns me is the proper parties for the allocation of fault. Mm-hmm. And as you know, there's an issue as to three entities, McDonald and Miller, and I think Peerless Pump. And my first question to you is there evidence in the record that your client installed, and I use that word carefully, as you know, installed valves and pumps from those companies?
He did install McDonald and Miller valves, but he did not have, there's no evidence in the record that he had any asbestos exposure from that installation. Because during installation, you don't have to go inside the valve, so it doesn't matter that there was asbestos packing or gaskets inside the valve. And the only flange gaskets, the gaskets used to attach the valves into the pipes, the only ones that he used for McDonald and Miller, the only thing he talked about were pre-cut gaskets. And installing a pre-cut gasket does not create asbestos exposure. So while there was evidence,
Weren't there occasions when he cut the gasket to install it?
in his work history generally, yes, but there was no evidence like that about this brand of valve. He said that McDonald and Miller provided some of the flange gaskets, but those were always pre-cut. And if they weren't provided by McDonald and Miller, then they're not attributable to that company either, if they weren't inside the valve.
Where did he say that those gaskets were always pre-cut?
Oh gosh, I can find it. Let me see.
You can wait till
Okay.
between now and rebuttal.
Yes, I will.
But
But,
take a note. Thanks.
Yes, he did. He was asked the pre-cut flanges, pre-cut flange gaskets, who provided those? And he said McDonald and Miller provided some of those, and some were from Garlock and some were John Crane, I believe. But there was never any discussion in the record of him cutting gaskets that were supplied by McDonald and Miller to attach into the pipes.
I'd like to step back to the answer you gave me a few moments ago on Judge Carroll's ruling on the actual ruling on the motion for new trial that occurred afterwards, where he,
Right.
and in that case, he prepared a written order, and I'm looking at Appendix 822.
Okay.
And Judge Carroll says, as I noted in overruling the motion for mistrial, aside from the brake line issue, I was not given an opportunity to pass on those things during closing argument by way of a timely objection. Then he goes on to quote an Eighth Circuit case, which he says supports the view that you have to make a timely objection. And then he wraps up a few sentences later by saying, I declined to exercise my discretion to take up issues that were not brought to my attention in the first instance at trial. So I read that as him applying the same standard he applied in the motion for mistrial. You read it differently?
Well, when he discussed why there wasn't prejudice, he did address things that she had said in argument that had not been objected to during the argument. So I guess that's why I read it somewhat differently. And there are certainly other things that he perhaps did not address, but some of the specific questions that I was given about, sending a message and some of those things that she said, I believe that he did consider those in his prejudice analysis. And so he must have been giving them consideration in that ruling.
Peerless Pumps, I want to go back to my third party. You talked about McDonald and Miller, but not Peerless Pumps.
I remember the details of Peerless Pumps less well because the evidence seemed even less strong of it, I admit, but I will also look for the citations for that one before rebuttal.
But I take it your position is, although there was evidence that he installed Peerless Pumps, your view is that there was no evidence that involved exposure to asbestos.
I definitely believe there was no exposure to asbestos from installation of Peerless Pumps, but I do not remember the details of the evidence around Peerless as well, and I will check that.
Is there a need for our court to send a message to the bench and bar that orders in limine should be respected? It seems like if too often lawyers for either side can cross the line without consequence, that it's going to water down the evidentiary rulings of the trial court. How would you respond to that?
Well, excuse me. I think that I do think that it's important for the parties to honor the rulings on the motions in limine, but I think that taking that out of the hands of the trial courts is perhaps not the best message. And if we do that, it leads to a lot more uncertainty. There are going to be a lot more cases overturned, and the point of the abuse of discretion standard is that we allow the trial court to consider first whether his rulings have been abused in some way, and if so, whether there's prejudice that requires him to do something. He had the authority to do that, and I don't think he had any unclarity that he was able to grant a mistrial and to hold people absolutely accountable for those rulings.
But shouldn't the lawyer who's listening to his opposing counsel cross the line have the option of not interrupting and waiting until a break or right after the argument to make his record and object, as happened with some of these line crossing incidents here?
Yes, I think they do, but that's not what happened in this case. There was the closing argument. Plaintiff's initial closing argument occurred in the morning. There was a break at lunch. There was no objection made, no motion for mistrial, no complaint about anything said. Then the defendant did their closing, and the plaintiff had her rebuttal argument. And again, nothing was said. The court was not asked to give any instructions or to admonish counsel. Nothing happened other than the objections made during argument until the following day.
Well, but as I read the Andrews case, and I've read it several times, I'm sure you've read it more times maybe than I have, but it talks about made before submission to the jury.
It says
And this was prior to submission to the jury.
it was prior to submission to the jury, but the case actually says at closing of argument and before submission to the jury. And the Andrews case talks about why we have rules for timeliness, and it's to give the trial court an opportunity to solve the problem prior to mistrial, to avoid a mistrial if possible.
Well, didn't the trial judge still have that opportunity when the motion was made?
By the next day, I don't think so. And in fact, the defense lawyer who made the motion for mistrial said none of these things can be repaired at this time.
So they
That's
didn't ask
always
for
the
it.
case, isn't it?
No, I don't think
But
so. I think that.
But the court had not instructed yet, so there could have been
But
some relief given, couldn't there?
Well, I don't think the defendant had taken the position that nothing that the court could do at that point would solve it except for mistrial. And the further you are, even if no other, I'm sorry, I'm blanked on a word. If nothing else, no other judicial proceedings had occurred, but so much time has passed that an instruction at that point is not going to be effective to direct the jury's attention appropriately. The defendant hasn't given the trial court an opportunity to correct short of a mistrial.
The trial court could have given some curative instructions if the court, as it said in its ruling, didn't find, I guess, I'm kind of blending the ruling on the motion for mistrial and for the post-trial motion as well, but couldn't they, at the morning of trial then, sat down and said, well, I don't think it was all that bad, and let's have a curative instruction, just making sure or re-emphasizing that anything that counsel said during closing, is not the law, or even corrected some of the misstatements that were made? Wouldn't that have been a possibility, or perhaps a better possibility of resolving the conflict here?
That would be another possibility. The trial court took the position that it hadn't been given an opportunity to do a meaningful opportunity to review those things at the time and deal with it for the jury at the time. It is possible the trial court could have done different things, but I don't think that's the way we should be reviewing it. I mean, maybe he could have even made a better call in what he should have said the next day when the motion for mistrial occurred. But I don't think that we should hold the trial court to the standard of making the very best call on every occasion to avoid reversal.
Well, and I'm not looking for perfection from the trial court either, but I'm saying after what I understand to be a really lengthy trial, now we're getting into a real critical stage, and a critical issue has now been brought to the court's attention. you know, if you end up having to take a whole morning, or, you know, I don't care if it's a day, and you excuse the jury, wouldn't that still be better than simply saying, you know, I decide that we're gonna go ahead and proceed, and no curative instruction, nothing else? Isn't that still a better course of action?
Well, again, that would be a possibility. I don't believe Weil-McLain requested any curative instruction. They took the position that there was no repair that could be made. So that would be asking the court to also make decisions on things that the defense counsel hadn't requested. Excuse me. So, the court could have done it differently, I agree. But I don't believe that the court was required to do it differently. I don't believe that the court abused his discretion in making the decisions that he did.
Okay. Ms. Farris, I see the timer is turned in the wrong direction.
Sorry.
So,
It's red, though, I see that.
yeah, your light just went on. You'll have rebuttal. Thank you very much. Counsel? Mr. Godfrey.
Good morning, may it please the court. My name is Richard Godfrey. I represent Weil-McLain. First, let me thank the court for the courtesies extended to me by allowing me to appear pro hoc vice. I get around the country a lot, and it's always a privilege to appear in another state Supreme Court. There were three errors that we raised below, three buckets of errors. One bucket was the improper closing, which this court has asked appropriate questions on. Second bucket was the allocation of fault under section 668, and the third bucket was punitive damages. Let me start by answering some of the questions that have been posed here this morning, I think. Counsel has a duty to adhere to the promises that counsel makes to a court. Ms. Dean made promises about what she would not do in connection with motions in limine.
I have a question. If we find that the allocation of fault was improper, we don't really have to address this issue, do we? Because we're going to send it back for a new trial.
That is correct. The importance of this issue, though, I think goes to Justice Waterman's question. This is an increasing phenomena that our trial courts face. And the Fixamore case from the state of Nebraska puts it very well in the quote that this court adopted that says the party who's the plaintiff or the defendant, as the case may be, that engaged in the misconduct has no standing to complain about being held to account. There are two duties.
One of my problems with that is that sometimes I tried some cases once in a while, and sometimes I knew the other counsel crossed the line, and I didn't do anything on purpose. I mean, so how's the court going to gauge when counsel lets them do it because it may be advantageous to them and doesn't let them do it and stops them? I mean, how do we draw that line without someone speaking up and saying, objection?
Well, this court answered the question already. Unless the court were to change Andrews, the court said that the counsel, who's the victim of the improper statement, should not be put into the Hobson's choice position of drawing attention to the unwarranted remarks. Now, in Ms. Dean's case, though, and this is important, because I sympathize with the question you're asking. Sometimes Mr. McCambridge objected, it was sustained, and she went ahead and continued anyway. So the notion and the argument that you just heard that, well, there could have been some curative instruction, he was never given that chance. So the mistrial motion is made at the end of the closing for compensatories. And the arguments are made. So now you have the closings on punitives. Did Ms. Dean suddenly stop making objectionable statements? No, she continued. She asked for the $4 to $20 million, Your Honor, during the punitive closing, after the record had already been made.
And that one bothers me. But I tell you, a lot of the statements that the Court of Appeals relied on do not bother me, and I want to explore that with you.
It's the theme.
Oh, no. Cross-examination of experts and complaining and raising the issue that you spent all kinds of money on experts and so forth strikes me as bread and butter credibility attack. As I read, and I'll just tell you, as I read the Court of Appeals opinion, they had a long laundry list of allegedly, or what the Court of Appeals felt was improper examination, and most of them I didn't find improper. I did have trouble with the $4 to $20 million, because I think that was kind of a comparative effort, and so I guess my tentative view is maybe the red flag goes up on that. But on the business about spending money on extensive studies and high-priced experts and all that kind of stuff, I'm not sure that that's not ordinary attack of credibility, but I want to invite you to tell me that I'm
Because
missing
I
the boat.
discussed this with the Court of Appeals. By the way, during the Court of Appeals argument, I raised the three issues. I've only made two improper closing arguments in my life in an appellate court, so I understand that your Honor's concern about it. And each time, they had the same ratio decidendi, which was that it's intentional thematic. So I agree that attacking an expert for how much they are paid, typical bias. But when the theme is that you wrap all that up and then you make the argument that given what that was spent on the defense is the basis for the damages award, that is where it all comes together as to the theme. And to go to your point, not all the comments were attacks on experts. For example, using Decision Quest to make graphics. That's not an attack on an expert with the cost.
Oh, but I'm not sure that was an attack, is a comparative wealth analysis.
It's a comparative wealth analysis, which is precisely correct. It's saying one of the reasons you should award the damages that we're asking is because the defendant spent this amount of money to defend itself.
Oh, I think it could be defended by saying, look, they came in with these fancy pants graphics. Don't be fooled.
That's not the argument that was made. The argument was made thematically, which was the defense spent all of this money. They've been doing this for 30 years. We need to send them message. This is a company that has not heard, like you had here in this community. There's no question, if you take one or two of these statements in isolation, they could be characterized as attacks on experts. When you do it the way she did it, it was a thematic approach. And the reason that we've submitted the supplemental authority is it's not unique to this case. This is the modus operandi of this counsel. That's why we submitted the case from Minnesota, where the mistrial was declared, where he talked about another case, and he warned the same counsel. What's interesting, though, is it's not the quantum. They identified 14. We'd identified 20, what we considered improper statements below. The Court of Appeals identified 14. But when you look at Andrews, and Andrews is instructive. I mean, I've read Andrews because Andrews, the law of the states are split on this issue in terms of when you have to make the objections. In Andrews, there were a total of 6 allegedly improper statements. 3 were made and sustained during the closing. Just like some were made and sustained here, we don't identify those in our argument. We're concerned about the ones that Mr. McCambridge was put in the Hobson's choice position on. 2 were then raised in motion for mistrial, and then 1 was raised at the end. There were 3 total. They pale by comparison here. So I agree with Justice Wiggins' point that if you agree on Section 668, either on statutory grounds or on the evidentiary grounds, it gets reversed, it goes back. But this goes deeper than that. I didn't raise this issue in terms of the oral argument the first time around. I don't know if you have a tape. I mentioned it and said this is an issue, but I commented and my remarks were devoted to the other 2. The Court of Appeals, each of the justices read the closing argument from start to finish.
Yeah, but the Court of Appeals, frankly, I think is off because of the extensive reliance on what I would regard as credibility attacks on experts. That said, using my screen, I wash out some of them, and there's a residuum that remain. And then the question is that residuum? I mean, I think you're right. I mean, I agree with your framework generally. It's got to be, I mean, generally pervasive and affect the trial and all that.
If there was nothing else other than send the message, that is precisely what Ms. Dean promised not to do, what the authorities of this court say you cannot do.
Yeah, but you
precisely
had a
what she
pretty
did.
good rebuttal on the send a message, it seemed to me.
Mitigation should not excuse misconduct.
It doesn't, but it may. I mean, in general, we try and affirm 3-week, 4-week trials.
Sure.
Just painting broad brush. That doesn't mean that that doesn't mean you don't have your challenges. But generally, we look for harmful error. And I'm a little hard-pressed to think that this was harmful error. I mean, you came back and said, my heavens, this was 30, 40 years ago. It's not been, you're sending a message to the 1950s or kind of whatever.
There are three questions for this court, and only this court can answer them. I'm just a counsel, will raise them.
Let me go to that, one of the other questions then. Where is your evidence in the record that the McDonald and Miller gaskets were cut before they were installed?
Okay, so it's in multiple points, but let me give you citations, in addition to what the Court of Appeals found. So McDonald Miller, trial testimony, volume 5, 1087, line 22, 1088, line 1. Question, now you know for certain that Bell and Gossett or McDonald and Miller used asbestos in the packing on the stem or in the body of the valve. Answer, they used asbestos, yes. Then the next citation,
Well, but that doesn't show that he's.
I'm gonna get there.
Thank you.
Not done. I said they were spread out through the record. I mean, I didn't try the case, so we don't have it all, unfortunately, in a neat package. Then you go to page 1088. This is line 6, how do you know that they used asbestos in the packing? That was in the stem of the valve, the gasket. Answer, when you take it apart, you can see the asbestos gasket, you can tell asbestos. He asked who manufactured, Bell and Gossett. Then on page 223 of the trial record, who are the manufacturers of the gasket that would have installed these valves in the workshop area? Answer, Bell and Gossett, Donald Miller. Then you ask on page 224 of the record, do you believe the installation of new valves, this is line 18, in any way exposed you to any asbestos? Answer, the only asbestos I would have had in the flanges, and those are the gaskets we discussed before. Answer, yes. Then you get to their expert, Appendix 419 and Appendix 420. Question, the next thing, did you see the testimony from Mr. Kinseth in relation to pumps and valves? They work with asbestos-containing gaskets and packing. Answer, yes, like I said, being a boiler installer, he had to work with boiler systems, the pipes, the valves, the pumps that work on that system, that make the whole system work. So yes, when he installed them, he would cut gaskets at time to install those pieces of equipment, yes. Then Appendix 420, do you believe that that work was dangerous work? This is our expert, by the way, Mr. Brodkin. Do you believe that that work was dangerous work that substantially contributed to cause the development of disease? Answer, yes. I mean, the range of exposure for gaskets is not dissimilar than the range we talked about with the rope, so we're talking about half that range of exposure. So it's spread through different parts of the record, but the Court of Appeals looked at it. We think it's supported for both of them. The Court of Appeals thought it was supported only for McDonald and Miller, but that's what the record shows. Now on Peerless, and this goes to the statutory question, on Peerless, it was a refurbishment issue, which they found was similar to real property. We think that that's not an exception under the statute. That's a question of law for this court. That's why we raised it. So our fallback argument is there's evidence of installation. If you accept our primary argument, it does not matter. And why does it matter? Because under the comparative fault doctrine, the whole purpose, or the ratio descendi, it seems to me, is to allocate fault to those who caused the injury at hand. And by excluding people on a statute of repose basis, you have done just the opposite of what the Iowa legislature, we submit, would intend. But let me go back to the three questions on closing, because this is, I think, important. Number one, in light of the facts, because you compare the facts of Andrew and the facts of the Supreme Court of Nebraska's case in Fixamore and the statements made there to the facts here, those facts in those cases pale by comparison. So what does Andrews mean? Number two, does this court want to countenance that type of argument? There are two duties that counsel owe to the court, in addition to the duty of candor. One is, if you make a promise to a court, you may regret it later on. We've all done that. We've made a promise and say, boy, I wish I'd known then what I know now. But that's not my option. My option is if I say I'm not going to make a send a message argument because it's so prejudicial, that means I adhere to that argument. And there's no amount of mitigation that's going to overcome that, particularly since that argument was made partly in the punitives after the objections were made. And finally, what is the message to the bar? I agree with Justice Waterman's question, and I think Justice Mansfield's starting questions. The bar has obligations to the court. I think you've seen this. I certainly see this in the courts today. The trial judge is put in an impossible position. I agree with you. He's sitting there for a 3 or 4 or sometimes a 10 or 15-week trial. But there have to be consequences, because if there are no consequences, it will continue. And we know with this particular lawyer, and this is the reason we submitted the supplemental authority from Minnesota, this is the modus operandi. There must be consequences. And if you read that transcript from when we submitted the supplemental authority, that trial judge had 2 cases with her. In the first case, called Conda, he didn't declare a mistrial, although he sustained and said this seemed to be a pattern. In the second case, it's the old dog bite rule. Bite once, the dog. Bite the second time, something needs to happen. So what is the message of this court? This is the Supreme Court of the state of Iowa, like any other state Supreme Court. What is the message to the bar? I think it's that simple. I agree with you. You don't have to reach it, Your Honor. I agree with you. You don't need to reach this question. But if you don't reach this question on this record, then I think you have to ask yourself the question, what would it take in a closing argument to cross the line under Andrews or Fixamore? What would have to happen? 15 misstatements? 20 violations of motions in limine? What would it take?
Was it a violation of the motion in limine to impeach the experts?
No. It's a violation of the motion in limine to craft the argument. It might be a legitimate impeachment.
The comparative.
Compare fault.
Yeah, the comparative.
And that's what she
analysis.
did. And that was the whole modus operandi. And it is just disingenuous after the fact to say, oh, we're just impeaching the experts. Because you wouldn't make some of the arguments that were made if that's what you were doing. We've all impeached experts. We know how to do that. But we also know what you don't do. And this is what you don't do. You do not need to reach that question. I was hoping you took the case to discuss Beeman, because if it goes back, by the way, and the evidence is before the record, then under Beeman, we don't think there's a punitive award. But we've made our point on that.
I'm going to bite on Beeman.
Good.
You know, Beeman says a couple things. First, it says, as of 1965, the evidence of asbestos and occupational harms was ambiguous. Proposition number 1. And then proposition number 2 is, well, so for a punitive damages award, the plaintiff cannot rely upon the general industry knowledge as of 1965. In this case, we're dealing with a later time. He allegedly worked through 1987. I know there's some challenge to that in the record, but there's some evidence that he worked through 1987. In 1972, OSHA made a determination about asbestos in the workplace, and then we have the 1974 OSHA citation. You know all this stuff. I'm setting this up. What I'm saying is that the posture of this case is different than Beeman. It's different than Beeman because it's not involving the state of industry knowledge in 1965, but it's involving the state of knowledge at a later date when there were additional developments. I think it's quite possible that the entire industry can act recklessly, perhaps, with an adequate factual showing. So I invite you to
2 points.
dissect Beeman.
Number 1, let us not confuse the evidence about 65 raw asbestos and raw asbestos products with encapsulated products manufactured. So what we're confusing there is front line versus end line. Because in this case, Weil-McLain is a purchaser. It's a secondary purchaser, so it's encapsulated rope. And the science on that was not the same, and that's why the industry at that time did not warn. And I agree with your point that the entire industry could choose to be negligent, but that's not the evidence here. That's the argument based upon John's Mansfield, which, by the way, was inadmissible evidence, about raw asbestos as compared to products that contained asbestos. And secondly, there's no evidence other than the raw asbestos evidence that draws the argument or supports the argument that you're making about later points in time. Our problem with the 74 citations is they were factory floor citations, which have, in the district court, found that there was no substantial similarity to what took place on the factory floor versus what took place when Mr. Kinseth was putting it on. But Beeman, I think, is a question of law. Now, the Court of Appeals said basically it's going to go back, and we'll see what the evidence is, so I don't need to reach that. We think if the evidence is the same, it would be appropriate for this court to say, as a matter of law, that evidence does not satisfy the Beeman standard But then again, to leave it to the sound discretion of the trial court whether the plaintiff has anything else. And I can understand the court coming out one way or the other. I am way over my time, partly thanks to Your Honor. But unless the court has any further questions, again, I want to thank you for extending me the privilege of appearing before you, and we would respectfully submit that the case ought to be affirmed in terms of what the Court of Appeals did, reversed, remanded, and sent back for a new trial. We do hope you reach the Beeman issue, but I understand the rationale if you don't. So thank you all very much. I appreciate it.
Mr. Godfrey, thank you as well. Ms. Farris.
Let's see, well, first to fulfill my promise to you, I did look some more at the evidence of asbestos exposure during installation. All of the information that we have from Weil-McLain about asbestos in packing and what happens with packing or what happens with removal of gaskets, of course, none of that is relevant if, as the court said in Pepper, we can't submit fault based on exposure for which the defendant would have had a complete defense. And so any exposure that occurred in refurbishment or any time that Mr. Kinseth would have had to open up a pump or valve, that would not justify submission. During installation, there's no exposure to packing at all. There's no exposure to internal gaskets. The only possible exposure, as Mr. Kinseth says, is to flange gaskets. Now, flange gaskets don't come with the pump or the valve normally, okay? They're not part of the pump or the valve. They're what's used to attach the pump or valve to the piping system, okay? So occasionally there's a manufacturer that will provide those with the equipment. It's not common, but it does happen. The only way that equipment manufacturer could be held responsible for those flange gaskets, though, is if they were the one who provided them. If Mr. Kinseth were just working with some other manufacturer's gaskets to install this pump or valve, plaintiff wouldn't be able to bring a case against the equipment manufacturer for that. And so Weil-McLain shouldn't be able to allocate fault to those equipment manufacturers based on Mr. Kinseth's cutting some third party's gaskets. I'm afraid I'm not saying that clearly, but the flanges are not part of the equipment. Now,
Could you address the Beeman issue and what evidence in this record was sufficient to submit punitive damages?
absolutely. In this case, of course, the evidence is that Weil-McLain took asbestos cement, bagged asbestos cement from Johns Manville, took it out of bags that had warnings on them, and rebagged them into plain paper bags. So they then distributed with their equipment raw asbestos without a warning that they received from another asbestos manufacturer with a warning. I think that by itself justifies punitive damages. I know that Weil-McLain has argued that the evidence that JM had warnings on their bags was inadmissible, but it was discussed by plaintiff's expert without objection from Weil-McLain, and Weil-McLain cited that testimony in their motion for directed verdict because they were arguing that Mr. Kinseth's company had also purchased asbestos cement from Johns Manville, so he must have seen the warning. So they did rely on the same evidence that they now say that we shouldn't rely on, but I believe that that is very good evidence. The fact that they were continuing post-OSHA to omit warnings on their equipment, they were cited for that, and continued apparently beyond the citation to issue the equipment without warnings, because neither Mr. Kinseth nor his brother nor Weil-McLain's corporate rep could remember seeing any warnings on Weil-McLain's product until at least 1978. So I do think that there's evidence that Weil-McLain was both reckless and justified punitive damages and did so in a different way than other companies.
Why don't you address the larger argument on closing, and let me characterize what I see as the issue. On the one hand, our cases are clear that an occasional misstep in the heat of battle is not going to lead to reversal. On the other hand, there's no question, and I think it's fairly stated, that if a theme of closing argument is an impermissible line, that is putting you in reversal country. It's obviously a spectrum. I mean, one or two small little errors won't lead to reversal of a 4-week trial. But on the other hand, if it's pervasive, if there's a thematic aspect to it, that is going to lend reversal. So I think you've conceded that there were a few, at minimum, conceded as I think you must, that there were a few missteps. But make to us the argument that they were missteps and not thematic. How should we evaluate this as we look at the transcript? We're all going to read it with care. So help us out.
Well, as far as a theme, if Weil-McLain is saying that there is a theme throughout the argument for which things that are proper argument become improper because they were woven into a theme. That's their argument. So the Court of Appeals apparently felt that way as well, or actually believed that some of the things that, as you've pointed out, were not actually improper argument the Court of Appeals saw as improper. So one or the other of those things is happening. Either the Court of Appeals believed that there was an improper theme and that made proper argument improper, or that many more things were improper than seemed justified. How do we deal with that? I think on these questions, I think it's an especially important time to consider what the trial court says. Because when you're talking about theme, and does something come across as a theme, the best place to see that is to actually see the argument given, not to read it on a cold record. And so when it's unclear whether these things that should be appropriate argument are actually have become part of an improper theme, I think you have to rely on the trial court's evaluation of the argument before him and before the jury before you can make that decision. And I'm not saying that there is never a time when a trial court could not see it and the Court of Appeals would still have to say, no, this was too far. I'm not saying that the trial court is the last word on this, but I do think that if we're talking about something that is, that it's unclear whether argument that appears to be proper became part of an improper theme, that is something that the trial court should be in a good position to see.
Ms. Farris, let me ask you a question about the allocation of fault. Mm-hmm. Aren't we mixing apples with oranges when we apply the statute of repose defense to the allocation of fault?
I don't believe so. The Iowa law, as I understand it, I remember Pepper in the name of the case. I can't remember. Is it Pepper versus Star Equipment? I can look and find the case. But as I read it, we cannot allocate fault to a third party if they would have a complete defense to liability. And any of these companies, if we tried to bring a claim against them for exposure to asbestos, actually any exposure to asbestos, we would not be able to bring a claim for exposure during refurbishment, which is what Weil-McLain relied on, that exposure during refurbishment. And there was no evidence of exposure to their products, to asbestos, from their product during installation. So I don't think that, I think Iowa law says you can't allocate fault if the plaintiff would have no recourse against those parties.
So the defendant then becomes responsible for the fault of some third party? Do you agree that's the result?
No. The law says that the only thing that's recoverable are this certain type of, the law says that none of this particular type of exposure is recoverable. And let me see.
Well, the evidence, maybe the evidence comes in on causation.
It did come in on causation, because Weil-McLain wanted to say, no, they were only exposed to other people's equipment, that exposure was much more significant, which is why the plaintiffs argued we needed to be able to talk about exposure to asbestos during refurbishment of Weil-McLain boilers as well, so that the jury had a full picture of where all of the exposures came from. And if it is true that really all of his exposure had only been to refurbishment of products, then Weil-McLain wouldn't have been taking on any responsibility for that, because they would have been out too. But the evidence of exposure to Weil-McLain, to asbestos from Weil-McLain products during installation was sufficient to support a finding against them. And I don't believe that the law requires the plaintiff to absorb every other type of, this is not really that different from any other type of defense that a party would have. You know, why would the statute of repose be put on the plaintiff where other sorts of affirmative defenses would not be? I guess would be my question.
Thank you.
Thank you.
Ms. Farris, thank you, and Mr. Godfrey, thank you again. The case of Kinseth versus Weil-McLain is now submitted, and we'll next hear the arguments in re the interests of A.S.